So, good morning, everyone. Thank you for attending this month's session of What's Your Plan? So each month, Assisting Hands brings in an industry expert to talk about issues involving seniors and aging in place. And so this week, we're really thankful to have Coryn Rosenstock, and she is from Frost Law. And I'll give you a little bit of background about us, and then I will let Coryn tell you a little bit about her, and then we'll get into the meat of what we're here to talk about today. So I started Assisting Hands, and we do private duty home care. We work all over Montgomery County, PG County, and Fairfax County, Virginia. And we put basically aids in people's homes and help reduce people's stress by being there when they can't be there. Our ultimate goal is to give knowledge and information to reduce the stress on families. And that's part of the reason why we do the What's Your Plan, to give people knowledge so they can help plan for the future and avoid the catastrophe, unplanned emergencies that so often happen to people when life happens. So in any event, I'll turn it over to Coryn, and we can talk more as we move forward. Coryn, tell us a little bit about you and your law firm.
Hi, everyone. I am Coryn Rosenstock. I am a senior associate at Frost Law. So recently, you may be familiar with our law firm, Altman and Associates. We merged into Frost Law, so that's where we are now. The focus of our practice is estate planning and administration. Our practice is primarily in Maryland. I am licensed in Maryland. We also do a lot of work in Virginia and DC. We also work with Florida clients. I went to GW for law school. I am working on my LLM in tax from Georgetown, and that's a little bit about me.
All right, so we are alumni, maybe perhaps generations apart, but I graduated from GW a long time ago, 1983.
Not too long ago.
No, yeah. So in any event, what we're here to talk today about is really kind of the plan. And it's focused now. I'd like to talk a little bit about estate planning and the kind of documents that people get included, because people often think about, oh, I just need a will. Well, but there's so much more to an estate plan. So if you could just give us a high level view of kind of what's included in an estate plan set of documents, and then we can delve into kind of the thoughts and questions around what people should be asking themselves as they put these documents together.
Absolutely, Steve. Thank you for bringing that up. A lot of people, when they think about estate planning, they think about what will happen with my assets after I die. And then the next logical thought for many is, well, I don't have a lot of assets, or my family situation is really simple and the kids will figure it out. My spouse will figure it out. But actually, estate planning is significantly about planning for while you're alive and how you want your assets and your medical care handled while you are alive, if you are unable to manage those decisions yourself. So primarily, in addition to the will, we're talking about an advanced medical directive, a financial power of attorney, a HIPAA release form, and then some other documents that might include a living trust or a revocable trust, which might help you handle your assets while you're alive. And all of these documents focus on managing yourself and your things, again, while you're living, if you cannot do so yourself. So the advanced medical directive has two parts to it. The first part is where you appoint an agent to make medical decisions for you if you can't make them. So you get to pick who you think will make the best decisions for you if you can't make them yourself. If you are incapacitated in the hospital, if you are just too ill to talk with the doctors to figure out a course of treatment, who should be sitting in that position and be capable of acting on your behalf? You have the amazing ability in this country to name the person who should act for you. The second part of the advanced medical directive is the living will. That is a direction to the agent you've appointed regarding your wishes, about life-sustaining or extraordinary measures. Do you want to be kept alive on machines? Do you want artificial administration of food and water? Do you want to be an organ donor? Do you have any specific type of needs or desires that you want administered, not administered when you're in different health conditions? So that is the advanced medical directive. And probably, Steve, for people you work with, they may also have a MOLST form, MOLST, in the state of Maryland. That is a medical order form that a patient can fill out with a doctor or a physician's assistant. It's a direction to medical staff as to whether you want certain treatment, you want to be resuscitated. So as opposed to a living will, where you tell your agent, so your family member, your friend, the type of medical treatment you want, in a MOLST, or sometimes called a DNR, you are directing medical staff or emergency staff regarding what they should do in an emergency situation, what type of treatment they're allowed to give you.
So let me stop you right there.
Sure.
So, because I get asked this question all the time, do I need both of those documents? Or if I have a MOLST, do I need other advanced directives?
Yes, you do. So the MOLST form is, again, it's a medical order. That's actually why you can't fill it out on your own or with your lawyer. You have to fill it out with somebody who's a licensed medical professional, because it's a direction to other medical professionals as to the treatment they should give you. And it bypasses anyone else. So they're directed to follow those instructions. People will paste that on their refrigerator next to their bed. So in an emergency, if medical staff comes to their dwelling or where they are, they won't give them CPR if that's a choice that they've directed. That is different from the type of form a lawyer will help a client fill out, the living will or the advanced medical directive, where you will just tell your loved ones what type of treatment you want going forward. So after that CPR has already been administered, or not, do you want to be kept alive on other machines? Do they have time to ask your agent, hey, do you want this treatment administered? So you should have both.
Gotcha. Okay. So now, at what age should you have these things? I mean, is that something that you need only when you get to, sort of later stages in life and you have a complex illness? Or do you need this when you're 25 years old?
So you are allowed to make these decisions as soon as you turn 18, because when you're 18 in Maryland, you are a legal adult. And therefore, your parents no longer have the ability to make the decisions for you. And at that point in time, you have the legal capacity to make, for example, an advanced medical directive. And arguably, anybody at that age should at least have an advanced medical directive. We do this for a lot of our college students. We have them come in, talk to them. Who do you still want your mom and dad to be making these decisions for you? We'd really like you to appoint them in this separate document so that the college can have it on file. The MOLST form, I don't typically see younger clients have. This is usually something that people obtain in the later stages of life, or potentially younger people who have devastating illnesses, who have a real strong conviction about what they want to happen if they are in an emergency condition. So much so that they don't want anyone consulted. They just want immediately for the medical professionals to do as they ask. So again, that's typically for an older client or a client, again, with a devastating illness. The advanced medical directive, because a big part of that is just appointing an agent to make medical decisions for you. And that can apply in so many situations. God forbid you're in a car accident, you're giving birth, and you want your husband to be able to make certain decisions for you at that time. That's really applicable to any age. So as soon as you turn 18, I would encourage people to have that type of document in place.
Okay. So now, you've talked about the making decisions, but then there's, how do you pay for it? Do you have to have a separate person to do that? Or can the person that has the advanced medical directives also make the financial decisions?
Great question. So it can absolutely be the same person if you want it to be, or it can be a different person. actually to make financial decisions. Some people, in fact, name a professional. They might name their accountant. They could name their lawyer. They could name a bank or a different type of company to manage their financial affairs for them. But importantly, it's done in a separate document. So one is an advanced medical directive and one is a financial power of attorney. And for these forms, each state has its own preference for how they want the form to look. Maryland has a preference, Virginia has a preference, DC has a preference. The documents that you execute while you're a resident in one state will definitely apply across the United States of America. However, we recommend that as soon as you move to a new location, you fill out and you consult with a lawyer in that location to make sure that the medical professionals and the banks in the local area recognize what you're trying to do.
Okay, so next question I have for you is, I'll call it the talk. So we have so often clients who all of a sudden they end up in the hospital and the documents are maybe on the fridge. So now the daughter knows that she's responsible for making the decisions on behalf of mom, but she has no idea what her mom's wishes are. So how do you encourage people to not just sign a document appointing someone, but actually go to the next step and have that talk with people?
Especially, I think for the older generation, I think that people, a lot of millennials and whatever generations between that comes after a millennial, we've been having these conversations for a long time. We saw people on the news who, like Terry Schiavo in her case, we've been having these conversations for a long time. We're familiar with organ donation. We talk about it with our friends and our parents, but maybe our parents or even our grandparents, if we're lucky enough to still have them in our lives, don't want to talk about these things. They're upsetting. Maybe it's taboo. I think, you just keep bringing it up as much as you can. It's a really tough conversation to have, and I think it's really dependent on the person and how you think you can get across them. Maybe in the most difficult type of situation, you maybe watch a relevant movie, have a conversation after the movie, just say, hey, mom, I read something in the news about this. Or I went to go see my own estate planning lawyer and they told me I really need to have this conversation with you. Just tell me, like, what do you want? What do you want me to do? Just tell me once and we'll never have to talk about it again. Just keep bringing it up as much as you can. Even though it's tough, it's really important.
Okay, so let's skip back to sort of the nuts and bolts of this. How do we go about, engaging a firm like yours? And I realize every firm has different processes and probably cost points, but can you give us a range of how long does it take? How do you do it? What's the process? What does it cost if that's a reasonable question to ask?
Well, how do most clients, a lot of people find us by word of mouth. Sometimes you just Google, estate planning attorney, Rockville, whatever location you're in, you see who pops up. Once you have identified one or a few people you'd like to meet with and talk to, you have initial consultations with them. You call them up on the phone, you ask what their process is, you see if you're comfortable. Your lawyer should be somebody that you are very comfortable with because you want to be able to reveal everything to them. And you should, because that's the way we're able to provide the most competent legal assistance to our clients is when they're fully open and honest with us. So our process is that we have an initial consultation. We meet with you, we figure out what your goals are, we figure out where you are in life and what type of planning we need to do and we should do. The typical time frame for this is 6 weeks after a client has retained us to work with them. We send them drafts of documents. They take the time that they need to review those drafts, to come in and review them with us if they would like to do that. We make changes. And then at some point, hopefully soon after that, they sign their documents and they have them in place. And we are always here as a resource. So when there are different life changes or when there's a different need, we are here to bounce those questions and potential changes off of, and to advise whether there need to be any alterations to the documents. In terms of cost, it's really variable. We don't have, we have ranges of prices, but it really depends on the different needs of the person. So some firms cost more, some firms cost less. I think it's just, you do your research and you find out who you're most comfortable with, who you think will provide you with the best service possible.
Okay, can you give me an order of magnitude? Are we talking a range of 2,000 to 10,000, or is it, it's $1,200, or, kind of just an order of magnitude?
Yeah, sure. I mean, I think that the range that you quoted is probably pretty standard, but I think, that goes from the most simple to more complex. And I think there are places you could go that might charge even less, but I'm not sure.
So let me address that with you, because you can go online and it says will online, and click the button and answer a few questions, and then you pay some small amount of money and you get a will. Why should someone not do that?
Do not do that. The reason is, these documents that you're creating are some of the most important documents that you will create in your lifetime. I mean, we're talking about who is going to access your bank account when you cannot access it yourself. Who will sign off on your taxes? Who will make your medical decisions for you if you are in dire need of somebody making a good decision? In other words, you don't want to get it wrong. And those documents, there's no guarantee that they comply with the local law. And as I had mentioned earlier, each state has its own preference for how they'd like documents to look and how they'd like them to be executed. Meaning, can you handwrite it? Do you need two witnesses? Who can the witnesses be? Can the witness be somebody that you've named in the document? How old does the witness need to be? Do you need a notary? It's not good enough to just have a printed piece of paper that you sign with your wishes. It may be completely invalid. And to the extent that you might say, well, at least it documents what I want, and hopefully a court would follow it. The idea there is that you don't want to have to go to court to have a court follow anything. You want to make sure that you do your due diligence up front to make sure that the documents comply locally. And the only way to do that is to see somebody who's licensed in the correct jurisdiction.
Gotcha. So are there laws for when you don't do anything? So I don't have an advance directive. I don't do anything. I end up in the hospital. Is it the hospital is just going to make decisions for me, or I'm married? Is there a law that says in the absence of the guy using common sense and having a document, his wife does it or his kids do it? Is there some guidance?
Under the law of Maryland and probably each state, for medical decisions, there's an order of preference, depending on whether you have a spouse, adult children, parents who are still alive. So there is an order of preference. And especially in an emergency situation, medical personnel, and we're talking about emergency situations. So I'm not talking about like, should we move mom into this nursing home facility or another one and she is incapacitated and we have time to think about it. I'm talking about you're in the hospital, they have to decide what to do. They will get consent from whoever they can that they can contact that they believe is the right person to talk to. But again, there is a default list for medical decisions. The same is not true for financial decisions. Financial decisions is a big can of worms, because if you haven't executed a power of attorney, which is a relatively small document, and you can execute with ease, especially if you see the right person to do it. If you don't do that, the only way somebody can access your bank account, if they're not named on it, is to go to court and open a guardianship proceeding. So the person who wants to be able to control the assets for you will have to file a petition in court, get medical notes saying that you're incapacitated, send notices to all of the interested parties, including members of your family, and hope that nobody objects. and then be subject to court accounting. So accounting for everything that they've done with your assets, which, you know, is a pain and invades your privacy because it's then open to a court proceeding. So again, for medical, there's a default list, but for financial, you're out of luck and we have to go to court.
Okay, so and this one I'll ask, I don't know if it's relevant to the folks on the call, but you know, we see it sometimes where, you know, mom or dad, maybe a spouse is living at home. They're really no longer capable of making their own decisions, but yet they never signed a document. And so now you have to go get a guardianship. How does that work? Because what I have been told is that somebody will be appointed as a lawyer to represent the guardian. So now you have the kid trying to get mom where she wants to be or where the family wants her to be. But if mom is resistant and maybe she doesn't know any better, you've now got a lawyer that you now have a controversy. How does that all work out?
Doesn't work out well. So what happens practically, Steve, is your parent is living at home with you and you need to access your parents' money in order to pay for their care, or you need to sell their property, or you need to hire people to do something for them, or you want to enter them into a facility, but you don't have the financial power of attorney to be able to sign on their behalf. So what happens? As you said, they have to go to court. So the child hires our law firm and we file a petition in court and we say, child wants to become guardian of mom. And here are all the reasons. I have these doctor's notes that say mom can't make medical decisions for herself anymore. Mom never executed any estate planning documents of her own, which is why, unfortunately, we're here to begin with. And here are her close family members, and these are the other interested parties in the proceeding. We file that in the court, and then the court will appoint a lawyer for mom. The lawyer for mom will go meet with mom and hear what mom has to say. And in a situation where everybody, including mom, agrees on who should be able to, or maybe mom can't agree at all, so she can't argue. In a situation where everybody is in agreement or nobody's putting up an argument, there's no problem. The court will appoint my client to be the guardian. There's no controversy. But as soon as the attorney for mom has questions or mom says, I don't trust my child, and the attorney really believes what their client is saying and feels that there is a real conflict, we have a controversy in the court, and it can take months and a lot of money to resolve. Ultimately, a third party may be appointed to be mom's financial agent and not or to be the financial guardian, and not anyone in the close family. So a third party might be involved in what's going on. And these things can last for months. Sometimes siblings have fights over who should be guardian of the property. That can cause issues, even if mom isn't putting up a fight. One family member might argue against another family member as to who should be really responsible for making these decisions.
So in the meantime, mom's assets are being spent to pay for lawyers as opposed to being spent to pay for care. So probably not the ideal solution. Okay, so on to another topic. I don't know if you know about the Voice Your Choice website. Okay, so apparently that's a web-based site where you can upload advanced directives and other documents. I don't know much about it, but I was going to see if you knew anything about it so we could talk to the families. So, all right, something we'll have to get more information on.
I'll have to look into that too. We do recommend that you tell your family where the documents are in your house, or that you email them over to your family. We PDF all of the documents for our clients so they can just send an email to the kids and say, here they are.
Gotcha. I know for us, we always encourage people to put the advanced directive portion on the fridge, because EMS will always look there. So they'll know who to call when there's an issue. And while they're not duty bound to honor it because it's not a medical order, if there's a DNR listed in it, they generally will try to comply with those documents if they're there. if they're sitting in somebody's safe deposit box, they're not actually particularly useful.
That's 100% right. So the medical directive and the will, the medical directive and the financial power of attorney, I'm sorry, we do not recommend that you lock those documents away anywhere because they can be needed in an emergency situation. You want them easily located. The will is another story because you don't need that until after someone has passed away. So we have more time to get to it.
Gotcha. Well, we have time for a couple of quick other questions. So I've got a question a little off the beaten path, but maybe some folks here have a child or a relative that is maybe not capable of caring for themselves and making their own financial decisions. And so in the will, there may be a need for some advanced planning on that. Can you talk about just a little bit about sort of special needs trusts and kind of what they are and why somebody might need something like that, and what are the circumstances? Just a couple of minutes.
Absolutely. So a special needs trust, there are a couple of different types. There's a first party special needs trust. So that's where an individual who has assets but might need public assistance for various reasons is able to put their assets into this first party special needs trust, and that gets reported to the state and it's accounted for, and they're allowed to apply for public benefits. So that's when I put my own assets into a trust. A third party special needs trust is probably more like what you're talking about. So that's when a family is doing their estate planning and they have a beneficiary that they want to support. And they know that beneficiary might need public benefits. They might need to go on Medicaid or other state-run benefits. So what we do is we put that inheritance into a special type of trust, which a trustee will manage for the person and make distributions to them, but only above and beyond the distributions that they would be able to receive publicly from the state. So the benefit of this is that if somebody who's on means tested benefits, meaning that you can only get the benefit if you don't have money to be able to pay yourself. If you are on means tested benefits and you receive an inheritance, well, that can count against your benefits. You might get knocked out of your benefits for a certain period of time, et cetera. But if we instead protect that inheritance by putting it into a special type of trust, you can maintain your benefits and you can also receive the additional benefits that might come from the inheritance.
Gotcha. Okay. So any topics that I should have covered that people always ask you about that I didn't in the couple of minutes we have left?
You know, we've really covered the really big topics of a medical directive, a financial power of attorney. I do get a lot like what will happen to the house after I pass away. You know, if there's a joint owner on the house, and it's with a right of survivorship, it will pass automatically to the surviving owner. If it's a joint ownership as tenants by the entirety with the surviving spouse, it goes to the surviving spouse. But if you own it all by yourself, it will have to go through the probate process. So that's something that we can plan around by doing a trust. We talk about that. Some people want to know, like, should I give my house away to my kids? And will that allow me to go on benefits myself, do some Medicaid planning? These are some questions that people have, but they all involve, that would involve a more long-winded answer.
Gotcha. Okay. So I guess we have a couple more minutes. I don't know if anybody's got any questions. If you want, you can certainly unmute and ask away, or you can put it in the chat. If not, I probably have one more in my bag of questions to ask. All right. Well, not hearing anything, I'll ask one more question. So as a practical matter, if you have an opinion on this, is it better to add a child or someone else to your bank or investment accounts as opposed to just exercising the power of attorney document? Does it make a difference? Is one easier than the other? What's the best way? Because oftentimes people just all of a sudden they're shut down. They can't actually access money to pay for things. And they've got to go through a process.
That is a great question. A lot of people put their kid on their bank account as a joint owner so that the child, for convenience purpose, can access the money. But what does that mean? After the person dies, the child is automatically entitled to all of the money in the account. That may not be what the parent wants or what the person wants, because legally then the child's entitled. But what if you have other kids? What if you have a spouse and you wanted the money to go to the spouse? Now, if you have a nice child, they're hopefully going to do the right thing. In our wills that we draft here, we address this issue about what happens if you put someone's name on an account for convenience purpose, which is what we would call this situation. Not truly a joint account because it's not both people who put their money in there. Instead, it's a convenience purpose that you've added somebody's name. I recommend highly against it. Instead, what you want to do when you go to the bank is add the child or other person as a power of attorney to the bank or other investment account, because each financial institution has a form that allows you to do this. So they have a form that allows you to add a joint owner, and they have a form that allows you to add an agent or a power of attorney. The agent or power of attorney does not own the money, and they are not entitled to the money when the principal account owner dies. They are only entitled to the money to use it for the purpose and benefit of the main account or the only account owner. The problem is that when you go to the bank, unfortunately, a lot of the people you may meet with are confused about this themselves. And they might tell you, oh yeah, that person will have access to your power of attorney. But then I look at the actual statement and I see you have a joint owner. So if you go to the bank, you should really be insistent that you're adding a power of attorney or agent onto your account as opposed to a joint owner. You can do this either by executing the form that the bank or investment house will provide for you, or you can actually, if you've done your estate planning, you can go with the document you've executed in our office, or the person you've named can, and they can add themselves with that document as the agent or power of attorney on the account.
Great. All right. Well, thank you. This is great information. If you have any questions for Coryn about estate planning, I'm sure she's happy to answer them. I believe her information is up on one of the slides. If you want, Coryn, you can type it quickly into the chat. There it is. Okay. If you have any questions about home care or about other things that may be beyond the scope of estate planning, you can certainly feel free to call Patricia, or you can call me. And our office number was on the screen somewhere as well. And we're happy to help. And thank you all for joining in today for this month's edition of What's Your Plan. You all have a great weekend. Thanks, Coryn.
Having me.
Thanks, Coryn. Great information.
Thank you guys so much. It's been a pleasure.
All righty. Bye-bye.
Bye.
Bye-bye.